We want that anchored in, that the president has exclusive Article 2 power to fire the head of the Office of the Special Counsel whenever the hell he wants. You know, that's not the same as dismissing the underlying litigation and dissolving the injunction. So what did he send in there? We don't know. So they don't want the Court of Appeals to explain that, because if the Court of Appeals explains that, that is now precedential for all of the DC circuit. Hampton Dellinger, the fired special counsel, now cutting and running. We know he sued in Amy Berman Jackson's court. She is a DC district court judge, an Obama appointee. And after Trump took office, one of the first things he did was can this guy. Led the Office of the Special Counsel, appointed by Joe Biden, went to school with Hunter Biden, and was hanging around trying to act, in my opinion, as a mole inside the agency. Trump fired him quickly. He sued and got shoved back in there. Remember, Judge Amy Berman Jackson said that he can be put back in, given access to everything, emails, powers of the office, and more, hardly without even hearing from Trump, without considering the national security concerns or anything else. And this begged the question, why is the court usurping the power of the executive branch and putting personnel into positions from which they were fired? Well, obviously, this was a battle. It went up to the Supreme Court. They held the case in abeyance, and we were waiting from some orders and decisions from the judge. Now, Amy Berman Jackson, of course, as a very reliable blue judge Democrat, came back and said Hampton can stay, granted the preliminary injunction, and said he can continue to act as a mole inside the agency. Then what happened is President Trump submitted an appeal, and the Court of Appeals came back down and granted a nice order. Here is what they said via an order, and there's no real long memorandum or opinion that is accompanied with this yet. It's just an order. So after this order came down, watch what happened with Hampton Dellinger. You can see, upon consideration of the emergency stay pending appeal and the opposition here too. So Trump, after Amy Berman Jackson said Hampton Dellinger can stay in power, appealed from her lower level district court to the Court of Appeals. An emergency motion for a stay. They say, we've read everything, and we've read the amicus briefs, and we construed more from Kathy Harris and the Government Accountability Project and more. We granted those briefs. The clerk is directed to file them. Now it is further ordered that the emergency motion for a stay pending appeal, this is from Trump, be granted, and that Amy Berman Jackson's March 1 order be stayed pending further order of the court, meaning Hampton is fired again, except to the extent that the order vacates the TRO entered on February 12th. The order gives effect to the removal of Hampton Dellinger from his position as special counsel. He got fired again, and Amy Berman Jackson kept him in there. How many days has it been? Appellants have satisfied the stringent requirements for a stay pending appeal. An opinion will follow in due course, right? Now, the opinion is the juicy bit. That's the good stuff. Like, this is great, but we want to know what their rationale is. We want that anchored in, that the president has exclusive Article 2 power to fire the head of the Office of the Special Counsel whenever the hell he wants. Now, it's further ordered that on the court's own motion, this case be expedited. The following schedule is now set: March 21, April 4th, and replies by April 11th. The clerk is directed to calendar this case for oral arguments on the first appropriate date. They should raise all issues, and to enhance the clarity of their briefs, you are urged to limit the use of abbreviations, including acronyms and more. Please hand deliver copies by so on, right? All of that. So Hampton Dellinger just got nuked by the Court of Appeals out of the District of Columbia. Judge Amy Berman Jackson just got reversed on that. And we read through two of her decisions and explained how ridiculous they were based on her reliance on, I think it was Humphrey's executor, as the sole basis for why Trump cannot fire the special counsel, saying that the special counsel's office exercised virtually no executive power anyways. It was a joke. Both of them were jokes of an opinion. And so now the Court of Appeals comes out and corrects the record. Now, what you'll see is they scheduled briefs, appellee's brief, the appellant's brief. So Trump and Hampton will have to submit more filings, right? And we'll go through this because we want Hampton to continue to fight for his existence. But at the time it stands right now, he is now removed again, okay, pending these appeals, because he's the one who brought the lawsuit. But what do we know from the cowardly Hampton Dellinger? His attorneys sent this one in, and here, this is Joshua Matz, all right? This little one-page paragrapher. Here you go. After all of Hampton's fighting for the law and for his position and against the unlawful firing on behalf of him and all these other people, here's what he writes. I write on behalf of Hampton Dellinger, plaintiff appellee special counsel. No. You forgot right here. The word you should have put in here is fired, all right? To notify the court that Mr. Dellinger has decided not to pursue judicial relief, recognizing his right to be the head of the special counsel. You're kidding. We are still negotiating with the government regarding the next steps to bring this litigation to an end. We're going to see the government responded to this. dismiss. We'll see what they say. What? You're negotiating? What are you talking about? However, Mr. Dellinger's final and public decision means that there is presently no live appeal for this court to address. What? And he's also citing this article. He's like, also, we wrote about this in Politico, state media from USAID. He drops his legal fight to get his job back. See, we also talked about it in the news. Wait, what? So did you file a motion to dismiss your case with prejudice and pay attorney's fees for wasting everybody's time? Or what? What did you do? Well, the Department of Justice responded to this, and here's what they said. Dear Court of Appeals, this is a weird thing happening here. We write in response to fired Hampton's letter. He's asserting that there is presently no live appeal for this court to address. You just gave us deadlines. So there is, obviously. The assertion is plainly incorrect. The government is currently subject to a permanent injunction, which is stayed only by virtue of this appeal, right? So Amy Berman Jackson's order is still in effect. The court has just stayed it and scheduled new deadlines. So this appeal remains live unless and until the permanent injunction from which it arises is dissolved and the complaint is dismissed with prejudice. So Hampton can't just send a stupid letter in. He should send in a motion saying, I'm now filing to dismiss this case and the appeal. So when he wrote in his little letter to you that his final and public decision to cease, quote, pursuing judicial relief, he says, that's not the same as dismissing the underlying litigation and dissolving the injunction. So what did he send in there? We don't know. Now, his assertion also, Hampton, that he's negotiating with the government to bring this litigation to an end is also curious because he has not proposed any stipulation under the federal rules of civil procedure. He's not sought our consent to motion for a motion to dismiss or anything. In fact, he has communicated that he would take no position on a motion to vacate the underlying judgment. But that only confirms that this appeal is not moot. Again, the appeal will become moot only if and when the lower court injunction from which it arises, the appeal is of the injunction, that is stayed. Hampton is now out, but it still exists pending the briefing and the further appeal. It's not dissolved. And the Hampton's case must be dismissed with prejudice. Now, a result that he has so far not done. So he can say the case is over, but it's clearly not. So even under his view, moreover, this court would still have jurisdiction to issue an opinion. That's what we really want. Why did you stay this, Judge? It's because Amy Berman Jackson completely rigged the entire process and has no power to do anything she did. So they don't want the Court of Appeals to explain that, because if the Court of Appeals explains that, that is now precedential for all of the DC circuit. Then everybody in DC looks around and says, oh, well, the Court of Appeals just said that Trump can fire anybody, anywhere, anytime for whatever. And that what Amy Berman Jackson did was reprehensible and illegal and wrong. So they don't want it. They don't want that opinion at all. Like, nope, we're done. We're not fighting anymore. You win. Just don't wreck everything. Okay. And Hampton and his attorneys are probably freaked out like they just poisoned the entire pot. One bad apple spoils the whole batch, as it says. So they have all these lawsuits that they're able to engage in multiple domains. But if the Court of Appeals comes back down and sets a blanket rule and explains, here's what a TRO does, here's what a stay is, like, who knows what is going to be in it, it could reverberate throughout the rest of the district court. So don't let them do that. This court said you were going to issue an opinion. Issue it. Their statement today from Hampton appears to be an attempt to prevent the issuance of that opinion, to stop it from coming out, which is all the more reason for this court to not abide by this procedural gamesmanship, okay? As other courts of appeals have recognized, the practice of bifurcating an expedited order with its reasoning is common, often necessary and constitutional. So you can issue the order that we just read and write an opinion separately, even if the case becomes moot, right? So in other words, we really want your opinion. Even if he comes around and does file a motion to dismiss and that whole thing goes away, you still want your opinion, even if it's been mooted between the issuance of the order and the release of the opinion, citing all these other cases. So please give us your opinion so we can take it and shove it in every other District of Columbia judge's face peacefully and say, read this. You have no power to do what you're doing. Stop trying to undermine the Constitution because you're so mad Trump won. He won. Get over it. Okay. Get on board. Let's save this country. Stop interfering with the will of the American people.